Not bad.
All rise.
Okay, everybody be seated, and we're on your case now. And you want her as your first witness?
Yes.
Okay, go ahead.
Under penalty of perjury, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Please be seated.
Good morning, Your Honor. For the record, Steve Dingle from the Marion County District Attorney's Office.
Please state your full name and spell your last name in the record, please.
Sarah Elizabeth Snyder, S-N-Y-D-E-R.
Ms. Snyder, how long have you been a district attorney?
I've been employed by the District Attorney's Office since October of 1996, so just about 3.5 years.
You were the district attorney on the case of the state versus Pamela Mazier in August of 1998?
That's correct.
Judge Lukanen?
Pardon me?
In the court of Judge Lukanen presiding?
That is correct.
Did you have any previous knowledge before that trial of the Gaston cases in the Marion County Courthouse?
Yes, I did.
And could you tell me what that knowledge was?
I was aware of the juvenile court proceedings, had read most of the documents that had been submitted. I didn't read all the police reports, but had talked to Bill Howell, who was the prosecutor assigned to the juvenile cases, regarding the proceedings.
These people are on a racketeering complaint, $500 million for their fraud and their criminal acts of pornography and sexual abuse against Melissa Gaston. And their criminal acts of pornography and sexual abuse against Melissa Gaston. And their criminal acts of pornography and sexual abuse against Melissa Gaston.
They're part of a racketeering case that's been dismissed.
It's on appeal right now, reinstated in the appellate court.
Your Honor, I'm going to lodge 2 objections. Number 1 is, I don't understand the relevancy of this to this probation violation proceeding. And number 2, I'm going to have to ask that everybody allow me to speak without interrupting, and also that the person who's questioning the defendant allow Ms. Snyder to answer the question before she asks the next question.
Yeah, that one I'll go along with, because I have to write down what comes
I'm
off
sorry.
there. The second thing is, I take it for preliminarily for a familiarity of what Deputy District Attorney Snyder has in regards to this case. I'll allow a reasonable latitude. Then we'll get down to business. The issue is, at this point, has there been a probation violation, and is it proven? And that's where we are.
Well, the issue, sir, is whether it had an inception in fraud and is void and unenforceable, because that's what
I'm allowing you a certain amount of latitude in order to get...
Thank you.
I take it
and my counter defense is this racketeering lawsuit. Isn't it a fact that you were also named in this $500 million racketeering lawsuit?
I was one of the named defendants.
Isn't it a fact that that racketeering lawsuit has now been reinstated in the Court of Appeals?
I quite frankly don't have any idea what the status is. My understanding is that it had been dismissed.
And isn't it a fact that Dale Penn is also on your boss? Isn't it a fact that your boss is Dale Penn?
That's correct.
And isn't it a fact that Dale Penn is also on that racketeering lawsuit?
He is also a named defendant.
Okay. So when we came into court in August of 1998 before Judge Lukanen, we had a four-day jury trial. Is that correct?
It's about 3.5 days. The jury was out a couple of hours on the 4th day.
Okay.
So.
Isn't it a fact that during that trial, you prevented me from speaking of the law to the jury about being banished from the courthouse?
I made objections as I saw fit under the Oregon Rules of Evidence. I don't think that you were disallowed from presenting a case that you felt was viable, and I made the objections as I felt appropriate as an officer of the court.
Isn't it a fact that you interrupted me every 2 seconds when I was speaking for 4 days to prevent me from getting my facts to the jury?
I didn't interrupt you with the intent to not allow you to give facts to the jury. I interrupted you based on legal objections.
Isn't it a fact you interrupted me every 2 minutes for 4 days while I tried to testify?
I have no idea how many times I objected during the
Frequently?
court.
Very frequently? You're under oath.
I wouldn't want to characterize it. I did object with much more frequency than I do in a normal jury trial where there's a legal, where there's an attorney who is on the defense side, but I felt it was my responsibility as an officer of the court to make objections, legal objections, as I saw fit.
Isn't it a fact that when my witnesses were testifying that you also continually objected to them and continually interrupted our testimony?
I did object often to the testimony. I felt it was irrelevant,
And isn't it a fact that after they testified and it was time to rebut, that you made no factual disputes of anything they said?
I don't recall the specifics. I know that I didn't dispute most of the facts because they were not relevant to the criminal trespass and the resisting arrest that I was prosecuting.
Isn't it a fact Judge Lukanen allowed the testimony as being relevant?
He's the judge. I made objections based on my knowledge of the law. It was his responsibility to determine if those objections would be sustained or overruled, and I was often overruled.
Okay. Isn't it a fact that every time that I tried to read the ORS statutes about being banished from the courthouse that you've stopped me?
That's correct.
And isn't it a fact that you would not allow me to say the word innocent?
That's correct.
And isn't it a fact that you would not allow me to say the word pornography?
That is correct.
And isn't it a fact that have you taken an oath to uphold the Constitution?
Yes, I have.
And isn't it a fact that you completely deprived my right of due process in that trial?
That is not a fact.
I'm going to object to that. That's argumentative.
She answered it all. Didn't ask an answer. She said, no, it's not a fact.
Isn't it a fact, okay, I said that there was no factual, and isn't it a fact that those 4 days of testimony of many, many witnesses of the racketeering evidence that you did not dispute one fact? Under oath.
I realize that, Ms. Gaston. I don't think that
One fact.
I didn't object.
I didn't ask you that.
Well, now,
I
wait a
said,
minute.
Okay, but I asked
What's the question again? Then allow her
I
the
want a
opportunity to
responsive
answer.
answer. I know how these DAs are, and I don't want to run around.
I don't.
Okay.
I just want, I'm going, you give the question,
Okay.
she gives the answer, and I'll make the judgment.
Okay, isn't it a fact that after 4 days of testimony of many witnesses of racketeering, conspiracy, heinous child sex abuse that's happened to our family, retaliation, malicious prosecution of Bill Howell and Dale Penn and yourself, isn't it a fact that after all this testimony and all of your continual interferences with the witnesses, that you never rebutted and never gave one factual dispute?
That's not correct.
Can you tell me what fact you disputed?
I disputed the whole claim that there was any racketeering or any
No,
conspiracy.
I said factual dispute, not just denial.
Factually, there was nothing to support
That's not
any
the question.
claim
I want
of
a responsive
conspiracy
answer,
or
sir. She's
racketeering.
running around the question here, and I really
I
want...
don't even understand the question, so
The question is, let me make a statement, then I'll ask it. I'll make this clear and certain. There were 4 days of testimony of many witnesses of heinous crimes of the state, many individuals, all named in the racketeering complaint, all guilty of affirmative defense verdict in this courtroom on April 10th, 1998, before all this happened to me. Isn't it... All right, we'll go through that. That's what we'll do. Okay, isn't it a fact that you heard evidence in that courtroom that it was retaliation, that I was maced in that judge's office right after the jury verdict that found them guilty by affirmative defense?
That was your theory.
Theory? Isn't it a fact that Judge Ertzgard gave a racketeering instruction to the jury in that trial?
He did.
And isn't it a fact that he said they could not find, yes, not guilty in that trial of stalking for writing a newspaper exposing state crimes unless the judges were knowingly involved in collusion and racketeering with other state employees? Isn't that a fact, what he said?
That is not the instruction that was given by Judge Erskard.
Are you aware of the record in that case?
I am. I watched the videotape prior to the trial that involved the criminal charges levied against you.
So you're telling me that that's not the very words of Judge Ertzgard in his instruction?
I would be very uncomfortable while I'm under oath to say that
I bet you would.
I would be very uncomfortable while I'm under oath. I would be very uncomfortable while I'm under oath.